The title for the session, the overall session, is Law and the Political, the Contemporary Moment, and Nikki's talk concerns complementarity and tensions between international tribunals and domestic courts. So I'll turn it over to you, Nikki. Thank you.
Wonderful. Thank you, Kamari, and thank you all for those really valuable early reflections. I also want to specifically thank Felix Inderhinder, Kamari Clark, Alphonse Molefu, and Sarah Kendall for decentering these discussions. I really wish I was in Kigali with you. I think I can already see that the orientation of how things are spoken about changes given their spatial and temporal locations. So I think it's a really wonderful initiative, and I hope we can continue to make the University of Rwanda a site for these critical discussions in transnational law. So I'm delighted by the initiative, and I also recognize all of the work, including that of Sarah Ali, to make these things possible. So thank you. Now, over the next 30 minutes, and I'm just going to start my timer on that, I want to talk broadly about my current research, which is focused on empirical work on international criminal justice with two main areas of inquiry. Now, the first of these areas looks at the interactions among plural legal responses to large-scale violence with a specific focus on Rwanda, while the second examines the wider extension of carceral power through public international law, looking across what is often termed core international crimes and transnational crimes, to see what I think this illuminates about the role of criminal law as a form of global governance. And now, while thinking around these two areas, and although they're related to each other, I'm going to focus on the first of these, as I think it starts to place international criminal law, and this is one of the great strengths and possibilities of thinking through and in and with Rwandan colleagues. Thinking through the Rwandan case study and thinking with Rwandan colleagues, as it places international criminal law as a part of a much wider set of possible responses to large-scale violence. And I hope that we can even push beyond the thinking around local, national, and international to start to think about what material responses to large-scale violence might look like and how this might necessarily take the form of enabling people to cross borders. And I think this then starts to put international criminal law into a much wider regulatory framework. And so I want to do this through thinking through what international, national, local, and most recently, transnational justice seeking in the wake of the genocide against the Tutsi looks like. So my current project builds on my earlier empirical work, which, as Kamari kindly indicated, came out in my monograph, Courts in Conflict, Interpreting the Layers of Justice in Post-Genocide Rwanda. And so I want to start briefly with some of the findings that came out of that work to then speak to how this is developing into my current interest, which looks at plural legal expressivism and how this is played out in the intersections between international criminal law and border control. So the book, Courts in Conflict, draws on interviews conducted over 3 periods of qualitative research in Rwanda and Tanzania. And in doing so, it offers a detailed comparative cultural analysis of the UN ICTR, the Rwandan National Courts, and the localized Gacaca courts. And of course, it's fantastic to have Alphonse and Felix's expertise in the room as well as we talk about these questions. Now, in the book, I interviewed over 100 judges, lawyers, witnesses, and government officials who have been involved in these 3 tiers of justice seeking. And what I argue is that within these different sites, in the wood-paneled halls of the ICTR, to the local Gacaca courts in Musanze with the Inyangamagayo, to the High Court in Kigali, what we saw was that these legal actors were ascribing very different meanings to their work. So at the ICTR, while there was a lot of disagreement among prosecution and defense over a wide range of topics, all of the participants saw the tribunal's contribution as centrally to be building this international legal justice. As one judge said to me, it's the building blocks of the ICC. Whereas once I was talking to practitioners committed to building the Rwandan criminal justice system, then the focus became on judicial and legal training inside of Rwanda. And that was seen as the major contribution of the Rwandan national courts. However, with the Inyangamagayo, and I was based primarily in Musanze for this work, the judges, they're the Inyangamagayo, as most of you in the room know, the lay ministers who oversee, the lay judges who preside over the Gacaca proceedings, their ascriptions of meaning focused much more on very specific information about where the bodies of individuals could be found and who should be held responsible for those deaths and who should be exonerated from them. It was a very localized account that was very focused on the names of the particular individuals. Names that I might add were seldom, if at all, given mention when talking about large-scale loss of life at the ICTR. Now, what the book argues is that this is important. It's important to understand how the legal actors who are situated in these institutions understand their work, because it helps us to explain how these courts then interact with each other, both formally through the transfer of cases between these jurisdictions and through the use of evidence that's raised in one court and then introduced in another. So those formal interactions, and also informally to go to that recognition of the lived experience, because we've had witnesses who've given testimony before one court, being tried by another, who these plural legal justice systems are not separated. They intersect intimately through their everyday lives. And so what I argue in the book is that what we see is that how one process is justified affects how the others are viewed and understood. So the international judges who see their primary commitment towards the building of case law that can inform this movement towards global justice, then assessed the other two processes on those same terms. So they looked at the Rwandan courts to the extent to which they applied the case law of the ICTR. And then they looked at the Gacaca courts and tried their very hardest to distance themselves from those proceedings, to say that, look, it's not our job to judge them. But this then ran into really, really tricky legal issues, because a large amount of evidence that had been brought before Gacaca was then being reintroduced into the proceedings before the ICTR. And the judges and lawyers, as a result of their reluctance to engage with Gacaca because of the different terms on which that justice process had proceeded, then didn't know how to assess the evidence that had been brought before Gacaca. But similarly, then the Inyangamagayo, who had dedicated hours per week and huge levels of relational capital to their engagement with the Gacaca proceedings, then criticized the ICTR, not because it had taken too long or cost too much, as is regularly stated, but rather because it had failed to ensure that those senior leaders had to account to the very immediate local community that these Inyangamagayo were engaging with on a daily basis. And so, Arusha was seen very much as a place over there and the individuals who are being tried over there have failed to have to give an account of their actions to us here, while we are requiring our neighbors to give those accounts to each other. And so we start to see how one can't necessarily say, oh, well, as long as we have multiple justice processes, we're all okay. Rather, we have to pay very careful attention to what these justice processes are understood to achieve and how that then informs their capacity to engage with each other, both through formal legal process of transfer of cases and evidence sharing, and also through broader ascriptions of meaning. And so it's now to these broader descriptions of meaning that I'm going to turn, because I've become increasingly interested in how we might think about, and I must say that some of this work is new, and so I'm testing some of these ideas, I hope. So I'm very open to response and feedback, but I'm interested in how we think through the multiple plural forms of expression that post-genocide justice seeking illuminates. And so since 2014, I have been mapping what has emerged as the deportation, extradition, and domestic trial of Rwandan nationals alleged to have participated in the genocide against the Tutsi that have been undertaken in 20 countries around the world. And in this mapping process, there have been 102 individuals of which there are current proceedings against. So I note that the Genocide Fugitive Tracking Unit, which is part of the National Public Prosecuting Authority there in Kigali, has issued over 1,000 indictments. But in my mapping process at the moment, I have identified 102 individuals against which there are actual legal proceedings at the current moment. And so I've published the early analysis of this work in 2 journal articles that I hope I can share as further reading, perhaps coming out of this lecture. And the first is in the Leiden Journal of International Law, and the second is in Theoretical Criminology. And so I'm going to go to the arguments of these 2 papers, but what I'm teasing out as far as my further work goes is how might we start through multi-sited ethnographies. How might we start to engage with this pluralist expressivist work, or to use Kamari's ideas about assemblage, these different assemblages where there is affective feeling, but there is also messaging, communication that is occurring, and so I want to think through that in light of this very clear expressivist turn in international criminal justice more broadly. So what I think we see in this tracking of these transnational cases is that international criminal law is being renationalized. And this is happening in a range of sites. It's happening through immigration law, and it's happening through increasing resort to universal jurisdiction in generally states in the global north. Now, as I said, the data set shows, and I think this is interesting, that proceedings have been undertaken in 22 countries. And so this is not exclusively the work of global north states. Rather, we're seeing different types of work happening in different countries. And I think this is where I'm going. So across the data set in Europe, we see proceedings that have occurred against Rwandan nationals who are accused of involvement in international crimes. In Sweden, Denmark, the Netherlands, France, Italy, Switzerland, Finland, Belgium, Germany, and in my current country of residence here in the United Kingdom. On the African continent, we've seen proceedings happening in the DRC, in Uganda, in Zambia, Malawi, Kenya, and South Africa. In North America, there have been extensive proceedings both in the US and in Canada. And in the Asia-Pacific region, we've seen proceedings in New Zealand. And so what I suggest in the first article is if we start to look at the proceedings, particularly those that are occurring in the European countries, we have, although the South African cases also illustrate this, we have to start to understand the work that international criminal law is doing within immigration regimes. And these bring up some uncomfortable conversations about the multiple forms of expressivism that are occurring. Because under Article 1FA of the 1951 Refugee Convention, it excludes individuals from the scope of the convention where there are serious reasons for considering that they may have committed a crime against peace, a war crime, or a crime against humanity. And this provision is seen by many as a way of ensuring the integrity of the asylum process while upholding the fight against impunity for international crimes. However, once we start to look at the specific cases, we see that these pieces of legislation are the Article 1F obligations, or in the case of the US, the obligations to remove any refugee protection for someone who falls within the persecution clause. We start to see that they're embedded in legislation that's domestically as well as internationally orientated. And when I say domestically orientated, it's orientated towards and embedded within legislation that is fundamentally concerned with immigration control, whether that's immigration control in the US or immigration control in the Netherlands or immigration control here in the UK. So the extent to which the wording of Article 1FA of the Refugee Convention is included in this domestic legislation differs. But we're starting to see the charge of involvement in an international crime getting a lot of traction in how immigration regimes in the global north are being constructed. Now, if, as Durkheim suggests, the exercise of penal power serves as a moment of collective expression of shared moral passions, how might we start to look at what moral passions are being addressed by which collectives and to which audiences? So Durkheim makes an assumption of this shared conscience collective. But rather, in this moment, in this increasing moment of transnational justice seeking, we are seeing the building of multiple conscience collectives. That, from my earlier interpretive orientated work, I think suggests that we are going to see clashes and points of misinterpretation that occur as this assemblage of multiple conscience collectives is being built through carceral law, through the use of criminal law. And so this sort of orientation towards expressivism is very much gaining traction in what you could say is the orthodox literature in international criminal law. So as ICL has come under increasing pressure, there have been two major touchstones have provided responses to the dominant critiques. The first is that cases before international courts play a crucial expressivist role, generating and legitimating new legal norms on appropriate conduct during war and towards civilian populations and protected groups. And then the second claim in response to the criticisms of ICL is that the future of international criminal law lies in its domestic application. Now, these two developments are linked. Fail, I think, to account for the potential plural expressions of this work. So while Margaret de Guzman, in saying that expressivism provides the best justification for the work of the International Court, recognizes that there are potential multiple communities, whether they're NGOs, civil society, the states concerned, and particularly the victim community, as Sarah Kendall and Kamari's work shows us so strongly the importance of this community as a legitimating factor in the work of international criminal law. So while these different communities are acknowledged, I think there's less attention given to the fact that these courts are expressing different things to different communities. And so, in the interests of time, I won't go further on the expressivist question, because I do want to get to what I'm suggesting may be expressed through these transnational cases against Rwandan suspects. So I'm going to turn to that now, although I'm very happy to tease out and further discuss the extent to which expressivism and Durkheimian notions of that in terms of what it, in terms of the communities that are being built around it may take us. But in looking at these 120 cases, I think that, and my current multi-sited ethnographic project is starting to explore this, I think that there are four moral passions at play. The first is that these cases communicate an ongoing commitment to recognize the universal wrong of genocide. And we must take this moral commitment seriously, but we must also recognize where and how it is playing out. And so one of the sites where I intend to look at this in further detail is in France, where we have seen multiple cases that have been that have been pursued through immigration law and through increasingly domestic criminal law and through extradition law. So the French cases, extradition was denied at the highest level of the courts. But what we have seen, and Felix's work is very important here, what we have seen is that the role of survivors in the diaspora has been very important for driving these domestic criminal cases. And so we start to see a particular French-oriented domestic diaspora community that's been the main driver and has gained very little traction for these domestic trials, which have really only gone forward after we've seen the final refusal for extradition to Rwanda of individuals accused of participation in the genocide. And so I think there's much to tease out there about the situating of these genocide survivor communities in France, their continued dedication to communicating this universal moral wrong, but how and when that has finally gained traction domestically, at least in part because of this rise of universal jurisdictions in Europe more generally. And I think then this goes to the second communicative function that I'm interested in, and which I think is most starkly visible in the US cases. And here we see that this charge of international crime is at least part helping to constitute and bring into being ideas of the criminal migrant. And this is a much less comfortable setting. So while my work is often theoretically informed, it's almost always driven by a moment of being situated in a particular place, a phenomenological moment that brings to the fore a question for me. And in this one, it was sparked on the 11th of March, 2019, when I found myself sitting in a US district court in Boston, Massachusetts, and it was a criminal trial. And the family of the accused were seated to my right. They were well dressed and huddled together, but they were also the only Black people in the room, with the exception of one of the 12 jurors. Suits, white hair, and leather law books ordered the spatial courtroom. And the jurors at that time were intently listening to a white academic on the stand, one who you're all familiar with, Phil Clark, which was the reason why I was in the room in the first place. And he had been brought by the prosecution to explain the context of the 1994 genocide against the Tutsi. And the central issue for the court was whether the accused, Jean-Leonard Tagania, had lied about his alleged involvement in the genocide in his application form. Now, why I think these cases are important is because they're doing some of that communicative work of the wrong of genocide, and the legal practitioners involved in them are very much seeing their work in those terms. But they're also doing key communicative work about the types of migrants that the international justice system is managing to exclude. And I'm thinking here about Anthony Angui's work, where these cases, which are cases of fraud and a charge of a criminal offense for an immigration fraud. Now, these frauds are normally about lying about who you married or, which border you crossed. But in this instance, the fraud is about lying about whether or not this particular individual was involved in the genocide. And so in observing these trials, we see this really complicated confluence of racialized criminal justice and the allegations of international criminal law playing out in a US domestic setting. Where and so I argue in the theoretical criminology piece, and I hope to continue to think through some of this, that what we see is race emerging in this fractured but nonetheless significant fashion in the trial, where the horror of the Rwandan genocide and the distance of the victims who come forward from Kigali to give this testimony starts to do a whole lot of racializing work of saying these are the types of people immigration law is managing to keep out, and this is the type of racialized violence that's occurring over there. And I think it's the discomfort that this expressivist work, when situated in a US criminal justice immigration case, necessarily invokes that I think prompts some of my thinking around these the complicated and intention moral communities that are being created through criminal law as the dominant response to large scale violence. Now I'm just going to check my timing here. I've got 5 minutes because I want to come back to that to pick up on it just as a final comment. But before that, I want to talk just briefly about the other two communicative messaging, which I again have to be explored in different sites. The third is ambiguous messaging about what constitutes a fair trial in Rwanda. And so what we see across these 102 cases is that the Rwandan criminal justice system gets assessed very differently, depending on which court is doing that assessment. So in immigration cases, we're seeing a very favorable reading of whether or not an individual could receive a fair trial in Rwanda. In some of the extradition cases, and we've seen some states extraditing and some not, we see a much more ambiguous account and contested and varied account of fair trial rights in Rwanda. And so here again, I think the situating of extradition law and immigration law helps to explain this. So in the UK, we've seen a refusal to extradite individuals to Rwanda. But we've seen increasing traction in relation to refugee and immigration-related cases. Now, that's because I argue that the extradition cases are fundamentally about a global North state looking at a southern state and assessing the extent to which it feels that criminal justice system meets the criteria that it has set for its own criminal justice system. The questions around citizenship and refugee status in the UK are fundamentally about belonging and the type of person who may or may not be seen to belong to this community. And so I think that helps to explain some of these different appraisals of the Rwandan criminal justice system. That, I might add, is to some extent epiphenomenal to an understanding of the Rwandan criminal justice system. And so the fourth area of expression is to a Rwandan audience, is to recognize that a lot of these proceedings allow the Rwandan state then to have a direct interaction with its diaspora community, both through carceral power and through presencing into those diaspora communities. But let me conclude here on this point of where might this take us? And so I want to go back to the Boston courtroom and to some of the thinking that has emerged in the US around the Black Lives Matter movement. Now, the Black Lives Matter movement has made a range of important claims. But if we take seriously the fact that international criminal justice may be doing racializing work, and that the renationalizing of international criminal justice is also doing problematic racializing work, particularly in immigration-related proceedings, then what might some of the challenge to racialized criminal justice in the US speak to the situating of international criminal law? And I think one of the things that it speaks to is a shift towards material responses to large-scale violence. A shift towards one of these, Tendai Chumi's work here I think is really important. One of these responses is that freedom of movement, or the capacity to cross borders and pay remittances, is the best way to challenge racialized borders and to redistribute, to engage in economic redistribution. And so let's try and, I think that at least in part, the Black Lives Matter movement challenges international criminal law to think more materially and to think about what redistribution must look like. Okay, let me stop there. I would be delighted to hear comments, reflections. As I say, these are some new ideas. I've published bits of them, but I'm trying to think about how I might bring them together. Thank you, everyone.
Okay, thank you, Nikki, and you've really given us a lot to think about, and it falls very much within the scope of the conversations that we've been having. So we have about 15 minutes, and is Lionel on the line now? Not yet? Okay, so we're okay. So does anyone want to get us started? Okay, Sarah Kendall then first.
Hi, Nikki. This was such a wonderful presentation. Thank you. And so it's not actually really a question, but more an invitation, since I know you were kind of cutting things short toward the end, to just expand a bit more on the third and fourth of the moral passions, because I didn't quite catch that.
Maybe if you explain.
Kamari, do you want me to respond, or should
Yes.
I gather a few and then?
Maybe afterwards, but I think it would be useful. We do have a bit more flexibility, and you did rush through it, and it really is the highlight of your presentation, and we're all quite interested in that. So if you could say some more about those last two.
Great. Yes, great. So I'm looking at just to sort of reiterate the four of communicating an ongoing commitment to recognizing the universal wrong of genocide, and then who constitutes a criminal migrant, and then the ambiguous messaging about what constitutes a fair trial in Rwanda, and then the fourth into a Rwandan audience of the presencing of the Rwandan state. Oh, sorry, that was my timer. The presencing of the Rwandan state into its diaspora communities. So, Sarah, I have to confess that in covering the ground that I did, I think I changed the order. So I can't quite. So maybe you could just clarify for me which of the fair trial and the diaspora are those the two that you wanted to hear more about?
The two, yes, thank you. And then when you reiterated it, I realized you had covered them. It's just that you hadn't had the chance, I guess, to expand on those two quite as much as the first two. And I was wondering, I mean, it's so interesting thinking about this third one in the context of the UK, the UK refusing to extradite individuals to Rwanda, and yet this kind of outsourcing of asylum claims. And I wonder if your work is addressing that as well.
Wonderful. Thank you, Sarah. And I really appreciate this question, because this is what I've been writing on inevitably over the last few months. So yes, so I'm sure everyone in the room is very well aware of the UK's externalization of its border policy. And I think that's my first point. That's what we should be calling it. It is fundamentally about the UK trying to defer, what's the right word here? Trying to fail to engage, trying to hand over its legal responsibilities, externalize its legal responsibilities to other countries. And so I think that we need to see this as the fundamental issue at play. The UK has legal obligations under the Refugee Convention, and it is those legal obligations that, in my view, must be the focus of the judicial review that is now coming up in September. It was supposed to be at the end of this month, but we've now seen it pushed back of the political changes here in the UK. So the first issue, as far as that goes, is that the UK, it is not about a Rwanda policy. The first issue is about the fact that it's the externalization of refugee obligations from wealthy governments to less wealthy states. The second question then is a question around why, and I've written a little bit about this, why was the first externalization policy of the UK government agreed with the Rwandan government? And here I think there are two things at play. The first is that the tracking of Rwandan genocide suspects around the world, and the fact that the Rwandan government has recognized that much of the way to get traction on these cases is through immigration law, which is some of what I've tried to present here, has meant that there are networks of people, individuals who know each other, and and many of whom there's been a lot of interaction between the Rwandan Public Prosecuting Authority and border control officials in all 22 of these states. One of them is the UK. And so I think there was an existing transnational network where there's this overlap between carceral control of borders and international criminal law that I don't think is being given sufficient attention, and I think helps to explain why the first deal was reached with Rwanda. Now, I think it's also going to this notion of that spatial situating informs how we understand these processes. We need to understand that this is getting viewed very differently in different places. So Rwanda has been, and many people in the room know this, Rwanda has been an incredible recipient of refugees. And these have been refugees predominantly from the DRC, and hopefully, and I see Felix in the room here, hopefully not further flows in that direction, but from the DRC and from Burundi. And this is consistent with refugee flows globally. I mean, as global South states that are holding and supporting refugee populations. And so the turn to a discussion of the capacity, like the technical capacity of Rwanda to house these refugees, misses the fundamental injustice in externalization policy. And the problem in the UK is that the UK legal system will shift very quickly to a discussion of whether or not Rwanda is a safe third country and away from the externalization. And the minute that happens, and unfortunately, we already see this in the litigation because it becomes individualized. So it becomes the individual refugee who challenges it rather than the general challenge to the project. And for that individual refugee, they're going to raise all possible legal arguments, of which the one that they're likely to get more traction on before UK governments is an assessment of whether or not Rwanda is a safe third country. And so this goes to exactly what I think my project speaks to, of how these networks develop, but also how the situating of the courts and the orientation, the legal orientation of those courts informs what those courts then express. So yes, I think so. That's what I want to tease out because through the fair trial question, because what we've seen across these 22 countries is this really diverse and really ambiguous assessment of Rwandan fair trial rights. The courts really haven't been able to do it. And so we've ended up with contradictory decisions. And so I think we have to start to understand how those courts are situated. Should I stop there? Sorry, I know I went on quite long. I can also talk about the final point, which I think comes out a lot in the South African cases. And I'm actually intending to go to South Africa to look at the cases of how Article 1F is being used in the South African context against individuals not who are accused of participation in the 1994 genocide against the Tutsi, but rather individuals who've been accused of war crimes in the DRC. So there are really interesting kind of new things that are happening in the South African setting.
Yeah, thank you, Nikki. Feel free to go ahead and expand on that. And as you're expanding on it, if you could also, in the context of the theme for this week, if you can help us think about the extent to which these are legal questions. Your question about the capacity to cross boundaries, to what extent it's the best way to challenge borders and redistribution, as part of your shift to materiality, is that a legal question? Is it about putting in place provisions that enable that? And what might be the other components of the nature of the political, because the theme for today is the law and the political. So if you can tease that out in that respect, that would be really helpful. And then I'm putting together a list if there are a couple of others. Okay, so Sarah Jane, anyone else that, okay, and yeah, Lucy. Yeah. Okay, great. Go ahead.
Great. Thanks, Kamari. So, I mean, I think the first thing I would want to say is that I think that needs more thought. So that's very much that kind of where the direction of travel is going. And I want to think about it further. I want to think about it further in so there is always a narrow legal argument. You can always position the law. And so maybe those narrow legal arguments need to be made. I I think they need to be made in conjunction with the bigger, with the broader question around what criminal law is doing as a form of racializing global governance. And so I think we can only start to see the best possible narrow legal form if we understand this relationship between law and the political, or between law and the moral passions of the that are at play here. And so I think one of the narrow legal questions is Article 1FA. Okay, is refugee law in any way the right place to be making adjudications on a different standard of participation for involvement in an international crime? So one argument is the argument against Article 1F, particularly if the way that Article 1F is being deployed is deeply racializing and furthering some of the really problematic racializing work that the International Criminal Court itself is doing, domesticating it to some extent. So I think there might be an argument against Article 1F, but I don't think that necessarily takes us far enough in terms of material responses, and so I think and maybe this ties back to the communicating of the reach of the Rwandan state into its diaspora communities and the presencing of the state there. It takes us a question around who gets to move in the wake of violence. So it's in the wake of large-scale violence that the wealthiest people have the greatest access to mobility, and so this access to mobility then plays out in who left Rwanda in 1994, and the way they left it and where they're now situated. That's led to this transnational penal project of the Rwandan. There's some. I think this is a longer story around the fact that that mobility in the wake of violence has always been unequally distributed, and that one of the possibilities there, I think, then is to think about how do we start to expand the capacities through which individuals can leave? And I think we've seen in the Ukraine that some of that is possible. So the EU, almost immediately came up with a collective agreement about how Ukrainians, and I note that the UK did not join that directive, but that to offer a fast track for Ukrainian refugees. And so I don't have an answer, but I think it might offer some constructive thinking.
Great, thank you. We'll turn to Sarah Jane and then to Lucy.
Okay. Hey, Nikki, thanks. This was really, really interesting and illuminating, in part because I've been interested in doing some work around the two cases in Philadelphia against Liberians who came to the US 30 years ago, were naturalized, and are now being prosecuted for immigration fraud. And so part of my question here, and so my research would be about, I'm interested in exploring how the Liberian diaspora outside of Philadelphia experiences this. Mm-hmm. But my question for you now is, why now, right? So in the case of these two Liberian defendants, they had been in the US for 30 years. And when they came to the US, the State Department knew full well, at least in the case of one, that they had been closely involved with Charles Taylor. So why now? Why in 2019, 2020, 2021 are we seeing these cases make their way through immigration courts?
And we'll take Lucy.
That is 100% the right question.
And then we'll just take Lucy's question and then turn it to you. Okay.
Yeah, so I was just interested in when you were talking about like an expert witness in the US case to contextualize the genocide, and I wanted to really hear your thoughts on how contextualization of a historical event differs depending on the type of case that it is. So it's about war crimes and potential involvement in genocide, but it is essentially a deportation extradition case, and how that kind of changes the contextualization of the atrocity.
Okay, over to you.
Sorry, Kamari, should I start with that? Okay, great. So on the Philadelphia question of why now, as I just said, that is 100% the right question to be asking in my view. And I think, my answer is that the rise of jurisdiction has happened at the same time as the rise of carceral border control in Western states. So that the renationalizing of international criminal law is doing a whole lot of work domestically around reinforcing and legitimating or offering criminal law as the legitimate response and the civilizing response to the uncivilized process of erecting racial borders and reinforcing the erection of the construction of those racial borders through criminal law. So I think it's really interesting that that's happening in Philadelphia. I think that the other side of it, though, and I think this is where, how do we tease things out through ethnographic work, and why the next site, I need to do more site-based work in France and in South Africa. The French cases, we're seeing this rise of jurisdiction, of universal jurisdiction. We're also seeing it in the Argentinian cases with the Condor trials, which remarkably, like this week, are now going ahead in Italy. But the French cases, we also have to take seriously the confluence of people who've dedicated 24 years of their life to try to pursue these trials and have had and have had kind of this continual state resistance, and suddenly it's doing a whole lot of state-based work, and it's getting much more traction. And I wonder how we and this is where the sort of speaking to and understanding the different positioning of the actual people involved and how they're ascribing meaning to their work becomes really important. Because I think my point is there's not one nice, neat story that, and so just how do we make more of those stories visible? Because certainly, for the justice champions, for the justice cascade, it's all about fighting impunity. Everyone's cheerleading, and perhaps for the border criminology people, everybody's feeling a bit uncomfortable. But actually, we've got to try to understand that in terms of how the actors involved in it are doing, and in terms of this communicative work and who's being spoken to. Lucy, on the expert witness and the different contextualizing. So thank you for this question, because it gives me a chance just to speak a little bit more about what I say in this theoretical criminology paper, because actually the contextualization of the genocide against the Tutsi was very similar in the cases in the UK Magistrates Court around fair trial rights in Rwanda, to the cases in Boston, to the expert witness testimony that was brought before the ICTR. So in all of them, the contextualization of the violence was the same, and that's actually, to me, what's interesting here, because you see the sort of the heady mix of international crimes, law and race sort of got brought into the immigration sphere, but we saw much of what we saw at the ICTR in Boston. So, for example, the credibility of a prosecution witness who had traveled from Rwanda to Boston was repeatedly brought into doubt because of the significance of a $71 per day diem for food allowance and a $40 daily reimbursement paid by the Rwandan government to their witnesses who traveled to give testimony. And this was repeatedly used as a way to undermine the credibility of that witness. And this was used, a similar approach was used at the ICTR. So there was an assumption about the economic positioning of these witnesses because they had traveled from Rwanda. And there was not only that, there was an assumption that that credibility would be called into question because they had been given $71 a day. That is an outrageous thing to suggest I would come and lie about about violence that had been perpetrated on me and my family in order to receive a $71 a day allowance, rather than the huge cost and the sets of emotional and relational networks that had to be in place to enable that person to give that testimony in the first place. I think it's a very strong example there of how the economic bifurcation, the global economic inequalities of distribution then play out in really small ways, but really significant ways in the courtroom. So I think that this contextualization, it's actually the similarities of the contextualization across the cases that's interesting to me.
Okay. Any other questions? Thais, did you want to go ahead? No? Okay.
So, I mean, Nikki, tell me more. I stepped out, so if I asked a stupid question that was asked when I was out, please shoot at will, But your experience being at the ICTR, and probably in an early stage of your work, as an external researcher, of course, I'm looking at that back with your body of work and then your book published and so on. What are the experiences? I mean, we have been discussing the many theoretical kind of concepts that apply to these kind of interactions. But very importantly, for example, before you, we had Florida, of course, that you know well, who was really giving us practical examples that speak very much to the many theoretical things that we have been navigating. So, what is your journey now? The Nikki researcher rather than the Nikki making concepts? Maybe positionality.
Felix, So thank you. I think that's a really great question.
But Nikki, think twice about answering it, because Phil did preface his comments with the fact that he lives with a lawyer and what lawyers are good for. So we did get a bit of the flavor and dynamics at play with political science and the positionality of a lawyer. So please go ahead, knowing that who came before you.
I almost want to thank you for that, Kamari, and then I don't, because this goes to our spatial positioning. I'm out of the room, and I feel like I might be at somewhat of a disadvantage, at least because I don't have the capacity to share a drink at any stage in the exchange. But so Felix, look, thank you, and maybe we could even have it as a conversation, really, because because you and I have had these exchanges for some time. But I think that it's incumbent to think about who our audiences are, and I think I've been increasingly and so in the theoretical criminology piece, I write a bit about what does it mean to write on race as a white researcher, and I draw on sort of two bodies of writing. So Samantha Weiss is a South African philosopher, and she argues in writing on whiteness that the moral response, the appropriate moral response, is to feel shame and to step back. And that is the correct moral response. But we look at the writing of Steve Biko and Sepp Ngozi on this. There is also the recognition of that within white audiences, within predominantly white audiences, there is a challenge to question and make and challenge, what Biko termed the white liberal. And so, I think that for my own positioning as a researcher, I think that the capacity to try to have some of the conversations in those settings where everyone is very sure about the moral certainty of international criminal law, I think to try to unsettle some of those is important. I think the other side of it, though, is sort of my continued interest and commitment to Rwanda as a place, and how place-based, more ethnographically oriented work can inform global discussions. And there I go to our work. So I don't know if Felix has had the chance to talk about it yet, or Phil's obviously been very involved as well, of the Aegis Trust Research Policy and Higher Education program, where I've had the privilege of being involved with what is now 44 fantastic Rwandan social science researchers who are asking very different questions about post-conflict reconstruction in the country. And that the privilege of that discussion, where where one has the opportunity to listen and read and learn from Rwandans who are deeply committed to and embedded and asking really challenging and important questions. And Felix, I mean, you know this work, and your work and your leadership in this has also been absolutely key. So I think I think it's the combination of those two things, of recognizing that at the moment, in terms of my spatial positioning, I'm within the white settings, and I address those white audiences. And in the Rwandan setting, I would hope that we can shift towards, and I think the summer school is part of this, the more of the listening and the dialogue. I feel somewhat exposed in answering that question, but so Felix, you have to step in and respond to it.
It seems a bit that it's as if I put you on like a prosecution kind of page to answer kind of charges, and that was really not the intention. Actually, my thinking even in the question was not really much in terms of like racial kind of let's say part of the ongoing conversation about race, but it was more really like an external researcher coming into Rwanda, ICTR, and it might be you, Nikki, or Lee, for example, who comes from Cote d'Ivoire as well, probably some of the things might be similar. And so we haven't had the kind of RPHG kind of conversation, so Nikki did plug some work, which I really believe is very important. So we did some work together with Rwandan researchers, where I said about enabling them at least to carry their voice in terms of being part of the debates we are getting into now. I advise you really to look at Genocide Research Hub, Rwanda, so it has .org.rw. You have quite a set of papers with quite a lot of different kind of questions Rwandan researchers propose themselves, but also they try to answer in their research. And increasingly much of that research has been published. And I put Nikki a little bit on spot because also it's a part of highlighting exactly how wonderful work in that area, for example, as a translation of the commitment to Rwanda she mentioned, of giving back probably to a society which gives us something in terms of research and so on as a field of her work. Nikki has been an advisor to that program since it started, every time advising very meticulous work of think of supervisors, but also on the whole, since you have to supervise, have to publish all kind of work in a very competitive journals. So Nick has done a fantastic work. I was not here to just say that, but it's important to highlight that kind of other way of engaging in conversations, if you will, with societies that, let's say, you subject to your own inquiries without being always the hovering, let's say, external actor coming in, taking what you need to take, and then going and making kind of grand, let's say, this and that statement and theorization. Back to you.
But I think that if we go back to the exposure that Nikki's describing, I think it's worth saying that many racialized scholars really appreciate when white scholars, I mean in your case, Nikki, white South African, are willing to make such bold interventions in this capacity. I think it's critical that work and that burden shouldn't simply be on racialized scholars, which it often is, in fact. And sometimes it is because of easier access, sometimes it is because the personal is political, so it becomes the first place, that even when we go into the work looking at different questions, these other questions, we can't escape them. And in fact, they write themselves into, I mean, in my work, I didn't go in looking for race in an African context. When I started in 2000, looking at the making of the Rome Statute and the implementation of, the PrepComs and what led to the statute, it wasn't a question of race, in fact, but I couldn't not. And in fact, then many of us didn't have the analytic capacity to make sense of that with the law, and struggled over the early years to think about what this was that we were seeing. And so it's to say that exposure, I think, is healthy, it's critical, and I think we're in this together as we figure out what are the toolkits that we have to think about things that don't easily align with race per se, but that, I mean, analytically in the kind of theorization of race that we see in these domestic domains, but that actually are so much. And so this analysis, triggered by Sarah Jane's question, is so important. The future work that you're doing around the kind of infrastructures that we celebrate with the Rome Statute and international criminal law that then have become, and this is the question, why now? Why now? Because of domestication of the statute, because of the right-wing pushback, because of the nature of the global tirade around refugeeism and IDPs and the kind of crisis with climate change and movement, and it's only going to get worse, and the pushback will only get worse. And so the sharpening of this tool with the domestication of these statutes and the availability of this criminal infrastructure to then move to extraditions when convenient some 30 years later, I think is profound. And to be able to embed that in a racial politics that it's at play, it's very much what Tendai is actually doing, which you talk about in your work, and people like Tendai who are looking at that convergence with race and critical race and migration and immigration need to continue to be joined with radical white thinkers who have the legal tools and are able to look at these articles and think precisely about the infrastructures that are enabling that to happen, right? What is the nature of that embeddedness, and how are they overlaid with a racial politics that in fact we're going to see more of in the coming period, as we can see. And I think, and some of my colleagues might want to also say something about Ukraine in this regard, and Nikki, you raised it in your discussion, that you said that you don't necessarily have available to you a way to think about the nature of the political, but when you look at what happened in Ukraine and you look at the possibilities that were political decisions enabled and processed through legality, we do see what is possible when there's will, when there's a form of alliance and racial alliance that works. It's easily workable. It's possible. It's not impossible. But we have ended with the impossibility around refugee questions and refoulement and the challenges around it. And I think that too is an opening that we can continue to think with, that we don't quite know what is beyond the law, but we do know that when necessary, it is possible, and these are political questions. So really thank you for that. And I don't know if you have further reflections on that, but we invite other colleagues to come in here, because we probably have another maybe 5 or 10 minutes if you'd like, before we move to Lionel.
I mean, Kamari, I'll come back on that just briefly, because I just think that's mostly to say, I just think that's really helpful to recognize, to look at what is what has been legally possible, what becomes legally possible at particular junctures, and then that gives us a window into the politics that's at play, into So I think just to take that and maybe I'll sort of think with that a bit more. I think the other thing of that interests me is the relationship between the empirical work So it's our positioning as researchers, but it's also the mapping and the way through which we describe the world as we find it in relation to a particular question. I'm interested in how we can bridge some of the really important critical work in international criminal law that's gaining traction, and some of the theoretical work in critical race studies into that empirical reality, into the messiness of those empirics. And I mean, Kumari, I think you've been kind of leading the charge in showing us how to do that. And I just think that there's a real richness there, because this goes maybe back to Felix's comment as well. There's an idea that somehow the empirics are in Africa and the theory happens outside of it. And so there's an epistemic battle that's at play here as well, where it's about recognizing and connecting up the really radical Black theorizing and the really detailed and careful empirical work that many Black scholars, including the Rwandan scholars who are part of this RPHE, are doing. And I think there's work to be done in meeting those, because a lot of the time, certainly, and Felix, I'll hand back to you. I don't know if you would agree on this, but with some of our colleagues, I'm thinking of Ernest Mutwarasibo, who did this really fantastic paper on resistance to the genocidal violence. So he deploys Arendt in making sense of that, of why an individual would resist and how an individual resisted through critical thought. But I wonder that the capacity to move beyond and to move beyond Arendt and to start to connect some of this really radical Black theorizing with this really impressive empirical work. Yeah.
Ooh, was that a question for me that I can't answer? That's not fair, Nikki. I guess we are in a space where we need to invent new tools. And what we know, at least from this experience, is that the capacity for both theorizing, but also for exploiting already what is there in terms of empirics. We look at it this way. All things being equal in terms of accessibility, means, and logistics, and so on, a Rwandan scholar studying Rwanda has some kind of key advantage, and that is language, that is culture. So when he has, and I'm not socializing like the local, the romanticized anything. I know that there are many externals who can do wonderful, better work, but all things being equal, they have that advantage, which is very key. But many, of course, are constrained by many things that we all know we have probably written about, which have more to do with, the system, the structures, the inheritance of whatever we have, especially in the socio-economic and all of the rest. So I guess what we have been doing together is exactly creating that space. So in practical terms, for example, what enabled that work to happen was Edistrat gave money apply for money and then get grants of around like £2,500 to individual researchers who will have also some kind of budget paid somehow to an advisor to see them through also the process. Some are experienced, some are less experienced, and at the end of the journey they are able to produce something. So we tried there the money was not the most important thing, but it liberated certain given time, for example, that otherwise they would not have to produce that work. So, and that for us was very key. So that infrastructure, those kind of needs, just to give them the tools that the majority of you guys here do have, especially those who came by plane here to Rwanda, do have, that's key to us. Then once that infrastructure is there, at least my experience tells me and teaches me that the issue about inequalities in theorizing, in creating, navigating the epistemologies, in entering existing conversation or engaging or creating new ones, I'm certainly convinced that that is very possible. We have a lot of already, many examples from Southern outstanding scholars who exactly do propose those kind of things when they are in the right conditions and in the right environment, I guess. Did that, revenge kind of question, was it answered? Maybe. I guess it was a revenge question, but I hope I answered it, Nikki.
Yeah, no, it was more an exchange than a question, Felix. So I appreciate your generosity in picking up the exchange.
All right.
I think there's also distributional questions on the African continent as a whole, though. So I was participating in the Law and Society Association conference last week, which is the global meeting this year, and there in the Africa Critical Research Network, South Africa predominates. So I'm not only of a racial group that oppressed in my own country, but my country is oppressing in terms of epistemic work on the continent as a whole. There was a point at which they said, is there a researcher from Central Africa who would lead in some of the reorientating discussions there, and no one was there. Well, there are a whole range of reasons why no one was there, which is why it's so great that your summer school is where it is. But still, we need to the whole turn in LA this year was towards the decolonial impulse, towards colonial histories, towards the change in not only who generates knowledge, but where it gets published and what it says and what gets theorized. And critically so decolonial beyond identity politics, decolonial is in substantive and spatial terms. And I think that that still reflects those that the progress is ongoing, that this and also that those, I think this goes on our PhD. One of the questions we often had was, we want to be publishing in Kinyarwanda, and we want to be publishing in Rwandan journals, which I think is a very legitimate position as well.
Yeah, that's absolutely right. In fact, I was there, but I was online on that LSA African meeting last week, and one of the things that I did, because I remember when they said, are there any West African, are there any East African volunteers, are there any North African, because all of the South Africans were heavily ready to roll up their sleeves and engage, etc. And after that meeting, I actually went to one of my students, Wumi, who's a PhD student. She's here in this room, and I said, well, I know you weren't there at LSA, but you have to get on that list, and you need to volunteer to do some of this good work, in fact, and to collaborate with others. So I think that there's mentoring that we can do as faculty, for those of us who are faculty, with students to put them in touch with other people to do that good work. There are a number of things that you've raised around publications. Felix has raised in the context of publications. There's standard setting that we can do around syllabi, what one of my colleagues and friends, Kelly Gillespie, calls curriculating, which is about often, these canonical texts get to be set as the core text in the field, whether it's ICL or international law or public international law. But what we can also do is create counter syllabi and counter texts and provide and really be radical in our citation practices. So ensuring that we cite each other, ensuring that we redirect our students in relation to that, and encouraging our students to be bold in how they think, in what they think. And I have a number of students that are very bold. I mean, one of them in particular who, you have to beg her to read Kant to talk about agency, and it's the right inclination, which is, this theory building is right here in front of me. Why am you forcing me to read Kant and go back to Pierre Bourdieu and read practice theory, when in fact, I have this and that and the other thing. And the challenge is being conversant, but being bold in the knowledge production that we insist on. And I think sometimes that's difficult, especially when when they graduate, they're teaching core courses and their expectations. And I think scholars like you and older scholars who can set the way in doing that curriculating work. And I think we have to do more of that work to open the doors, but also to encourage new standards and norms around which we understand. So the grants, I think, their curricular work, the training, the mentoring, and theory building, theory from the South, whether it's in Colombia or elsewhere. And so the last thing I wanted to say, and then what I'm going to suggest is that we close out the session, and the bus is waiting for us downstairs, and we have other sessions after lunch. But what I wanted to say is that often these difficult questions are questions that are discussions that we have in closed doors. We have, what is it called, the rules out of the UK, Chatham House rules. And many times they're things that we feel can't be said on record. And sometimes those issues have to do with race and the ways that we're treated, the internal politics, and they're not things you write about, but they're key and central to the infrastructure of the way that courts function and the way that law functions and the ways that people see themselves in relation to others. And I think somehow we have to also continue to talk about how that's imbricated in the work that we do around justice writ large. So there's a lot of work ahead, and I think we've touched on many, many issues for today. And Nikki, our only regret is that you're not with us to have drinks and eat this lovely food with or without pepper. We'll interrogate you on which side of the spectrum, because we had a court case last night over dinner about crimes against humanity and the pepper eaters. What's it called? Pandanda? What is the...
Akabanga.
Akabanga. We heard all about Akabanga, and actually Akabanga tasters are on trial right now, and some are going to be appealing, in the days to come. But so we're sorry you can't be here with us. We hope that in subsequent years you can. And we do have a gift for you, which we'll give to Phil. It's a gift that we've been giving to all of our lecturers who have joined us. So again, can everyone join me in thanking
Wonderful. Thanks, everyone. Thank you.